Hello, I'm Rich Hammer. Our focus in this presentation is responding to allegations of child sexual abuse within the church. I will be addressing 8 key topics: the legal definition of abuse, responding to an allegation of abuse, documenting the allegation, reporting the allegation, responding to the alleged offender, communicating with the congregation, providing support to the victim, and responding to the media. Let's begin by looking at the legal definition of abuse. All 50 states have enacted child abuse reporting laws in an effort to protect abused children and prevent future abuse. Child abuse is defined by most statutes to include physical abuse, emotional abuse, neglect, and sexual molestation. A child ordinarily is defined as any person under the age of 18 years. Some states limit reportable abuse to abuse that is inflicted by a parent or caretaker, and so it is important for church leaders to be familiar with their own state's definition. Most church leaders are not prepared to receive an allegation of child sexual abuse. A pastor or church worker may be the first person to learn of the abuse.
I've had some children and the first person they disclosed to was somebody from their church, not from, or from school. Those are very common situations that come up.
The information may come from someone other than the victim.
A lot of times a child that's been molested or has had any kind of experience like that will tell another child. And they'll tell another child before they will an adult. And then usually those kids will turn around and tell an adult.
In almost all cases, both the sharing and the receipt of such information is a troubling, difficult experience. Emotions run high, and an untrained church leader can take a bad situation and quickly make it worse.
Here they are in a place that's supposed to help them spiritually, that this has, in fact, caused harm to their child. I think that it would be just a terrible thing.
The biggest mistake would be to act like it doesn't happen or act like it needs to be something that they need to just keep under wraps and forget about. It's easier to ignore something this difficult because no one wants to believe that would happen in their church and in their family. But it does, and they need to be ready for it.
A church leader that is prepared and trained can provide responses and initiate actions that will be helpful to everyone involved. At this point, don't try to form conclusions concerning the truth of the complaint. Rather, focus on 3 simple points. First, ensure that the complaint is being taken seriously.
Because they're not believed. And I would say if somebody comes to you and says that, somebody has touched me inappropriately, don't brush it off.
We take every allegation very, very seriously, very quick to respond.
Second, be sure that proper follow-through will occur. And third, assure the victim and the victim's family that you desire to extend care and support in whatever ways possible. Let's look at some examples of appropriate and inappropriate responses. First, avoid the classic and common responses of denial, minimization, and blame. These alienate victims and make matters worse. Imagine you are a victim and you have just shared for the very first time that you have been molested, and this is the response you receive.
I can't believe it. This seems impossible. You're not making this up, are you?
This response is known as denial and is inappropriate. An appropriate response would be something like this.
Thanks for sharing that. I know it's hard for you to share something so intimate and so personal as that, but you did the right thing in telling me.
Another form of denial often occurs when the alleged offender is a trusted member of the congregation, which generally is the case.
The more serious and dangerous the offender, the more practice they will be at fading into the woodwork and not being noticed, because not being noticed is their stock in trade. So they don't look like somebody who had molested a child, and in fact, they appear to be the person you would least believe. So the most commonly heard statement is, "Oh, I couldn't believe he would do such a thing like that." He would be the last person I would expect. Well, that's exactly right, because that's the nature of the offense, and that's the nature of the offender.
Saying, "I know him, I can't believe he would do such a thing," is an inappropriate response. Here's an example of a better response.
I want you to know that we take your allegations seriously.
It's important that victims know that you take their allegations seriously.
The victims oftentimes don't want to say anything bad about the offender because the offender is someone who's well thought of, and the victims are convinced that nobody would believe them or take them seriously.
In addition to avoiding statements of denial, you should also avoid any statement that minimizes the nature of the abuse. Here's an example.
Maybe you're overacting a little bit. Doesn't sound to me like that much happened.
A more appropriate response would be something like this.
I'm very sorry about what happened. We will do everything we can to help you.
Finally, church leaders often make comments that shift the blame and the burden to the victim. Here are several inappropriate responses.
Did you try to stop him at all? You share some of the blame for this. Man, this could ruin our congregation. You're putting me in a tight spot. You know, it'd be better if you just forget about this. Forgive and forget. Put it behind you.
These responses only make matters worse. A better response would be something like this.
You've done a very courageous thing today. This is hard for you to talk about, and you did the right thing in telling me. I want to let you know that our church leadership takes these things very seriously. And we're going to do all that we can to help you work through this situation and to make sure nothing like this ever happens again in our church.
Church leaders must work at creating an environment that lets victims know it is safe for them to come forward. Dave was molested by his pastor when he was 11 years old.
I think the number one cause of allowing these predators to keep preying on children is secrecy. The predator is not going to tell. Unfortunately, a lot of times in the past, the church didn't tell. And who that leaves is the victim. And because of the type of crime that this is, it's so difficult for the victim to tell. But the only way that the authorities can protect society from these predators is a victim has to come forward. They have to tell the truth. They have to say what happened to them. As painful and as difficult as it is for me to tell so many people what happened to me when I was 11, I'm so grateful that I've had that opportunity this year.
Let's go ahead and look at documenting the allegation. You want to collect some basic information to substantiate the complaint and that you will be able to share with the authorities when you make a report. This is not an investigation. Any investigation should be left to the proper authorities. Here is some information to collect that should be confidentially maintained. The name, age, gender, and address of the victim, the name, age, gender, and address of the alleged offender, the nature of the sexual misconduct alleged to have occurred, how many times the alleged misconduct occurred, the date and location of each incident, the relationship between the victim and the alleged perpetrator, other evidence such as eyewitnesses that support the allegation. When collecting this information, always remain sensitive to the needs of the victim. As soon as you receive information indicating that an incident of child abuse has occurred, it needs to be reported.
Their first steps would be to notify the Department of Social Services.
The decision to report the allegation should take into account several factors. First, check your state law. As I noted earlier, every state has a child abuse reporting law. Make sure you understand how your state defines abuse. Most states define child abuse to include physical and emotional as well as sexual abuse. Some states limit the definition of child abuse to abuse that is inflicted by a parent or caretaker. In other states, reportable abuse refers to any abuse, regardless of who committed it. Second, determine if you are a mandatory or permissive reporter. Mandatory reporters have a legal duty to report known or reasonably suspected incidents of child abuse. Permissive reporters do not have a legal duty to report, but are encouraged to do so. Both mandatory and permissive reporters are legally protected for making reports as long as the reports are not known to be false or made maliciously. If you are a mandatory reporter and fail to report a known or reasonably suspected case of abuse, you could face possible criminal liability. Also, a failure to report could result in possible civil liability under state law. It is possible that victims of child abuse may sue a pastor or church leader years later after they reach the age of majority if they learn that these individuals were aware of the abuse but did nothing to intervene or report it. If you are not sure whether or not you should report the case, it may be helpful to call the agency that receives reports of child abuse to discuss the facts of the case and determine whether or not a report should be filed. Such a call can be made anonymously. Be sure to make a telephone memorandum of such a conversation and have another person on the line who can confirm that you made the call. It is also advisable to discuss these cases immediately with a local attorney. An attorney can assist in deciding whether or not to report alleged abuse or molestation. By reporting the abuse, you are turning the case over to the civil authorities for their independent investigation.
The best thing to do is to handle it over to the authorities who are used to dealing with that issue, and then they can make a determination if any more action is necessary.
Furthermore, if the church gets involved too quickly, it can create complications for the investigation. Both the church and the victim are better off by letting professionals do their work.
Some of the investigative tools that we use, we need a little anonymity with that. We need the perpetrator not to know that these things are being looked into. If they have the opportunity to find out that they're being looked into and can get in contact with this child, talk to the child about not telling, they can make threats to the child. Of course, they can always take off. So anything that happens needs to be investigated by people who can actually truly do something about it.
The actions of the civil authorities can be helpful to the church in formulating its own response in a case involving inconclusive evidence. The actual determination of child sexual abuse is often difficult.
The assessment of child sexual abuse is actually a complicated process. I've very rarely have ever seen a child in just one session to make an assessment about that. It generally is over a period of time.
In some states, the clergy penitent privilege exempts clergy from reporting child abuse if the abuse is reported in the course of a privileged communication. The clergy penitent privilege varies from state to state. A local attorney can assist the pastor in deciding if a privileged communication took place. Once a report is made, contact your insurance company and let them know the status of the report. If the alleged offender is an ordained minister, contact the appropriate person in your denomination who handles allegations of clergy misconduct. Let's look now at your response to the alleged offender. First, do not contact this person until the police or state agency has been notified and gives you instructions on what they want you to do. They may request that you do not contact the alleged offender until they have the opportunity to conduct their own interview. The investigation should be conducted by the state agency and not by the church. One of the major decisions that must be made following the initial complaint is what restrictions, if any, should be placed on the alleged perpetrator of the abuse if that individual is a paid employee, volunteer worker, or even a lay leader within the congregation. First, what are the implications if you do nothing and permit the individual to function as if no allegation had been made? This represents the greatest legal risk to the church if the allegation is determined to be true and the individual continues to engage in sexual misconduct. Punitive damages could potentially be assessed against both the church and its leaders. Second, you may decide to restrict the individual's activities. While the complaint is being investigated, the church may limit the individual to low-risk activities that pose little threat of sexual misconduct. While this does not eliminate risk, it does reduce it. Finally, you may place the individual on a paid or unpaid leave of absence. If the allegations are substantiated, dismissal often will occur. If the allegations are found to be false, the individual should be reinstated. If the findings are inconclusive, the individual may or may not be reinstated based on the totality of the evidence. In such a case, if reinstatement does occur, additional restrictions should be considered concerning contact with minors. It also may be helpful to talk with the person who investigated the case on behalf of the police or local child protection agency. This person may be able to assist church leaders in deciding whether or not to terminate the suspect. All allegations of sexual misconduct should be treated similarly. Sometimes churches treat male and female employees differently from one another. Failure to treat similar cases similarly can result in a civil lawsuit based upon discrimination against the church. A congregation often feels devastated following an allegation of child sexual abuse. It is vital that church leaders communicate appropriately with the congregation. Maintaining confidentiality ranks as a high priority for all church leaders involved in such cases. Often, however, allegations of sexual misconduct require that a church staff member take a leave of absence during the investigation. That may be for a few days or a few months. Or a staff member must be terminated and congregational members may be misinformed or have no idea why the dismissal occurred. Some see church leaders acting indiscriminately and believe their actions reflect poor judgment or even worse. Supporters and friends of the dismissed staff member can be ruthless in their attacks on church leaders.
You can see a church almost divide right down the middle.
Church leaders want to clarify their actions to the congregation, but are afraid that if they do so, they may be sued for defamation or invasion of privacy. Some church leaders throw caution to the wind and defend themselves and their actions as they describe the sordid details of the misconduct during public services. Both extremes, to say nothing or to announce everything to everybody, miss the mark and make the situation worse. To say nothing creates suspicion and backlash that jeopardizes the ministry of a church. To say everything can put the church and the leaders at legal risk. Fortunately, the courts have addressed this issue, and a third, more desirable alternative exists. In some cases, it is advisable for the church board to inform the church members of incidents of sexual misconduct occurring on church property or in the course of church activities. Such communication should be done in such a way that is protected by a qualified privilege. To illustrate, in one case involving a letter sent to church members by the church board concerning the dismissal of a staff member, a court concluded that church members have an interest in receiving information from their official board, and so the board's letter was protected by a qualified privilege. This means that the information shared cannot be defamatory unless it is made with legal malice, meaning that the persons who communicated the information either knew that it was false or shared the information with a reckless indifference as to its truth or falsity. The court concluded that the board had not acted with malice, and so their letter was not defamatory. The court emphasized that the board communicated with only members of the church who attended a congregational meeting, and that no non-members received the information. The qualified privilege that often protects information from being defamatory only applies to information shared with persons having a direct interest in knowing about it. This usually applies to fellow church members, meaning that a good deal of information that might otherwise be defamatory can be shared with members about matters of common church interest, unless, of course, those persons who share the information know that it is false or are recklessly indifferent as to its truth or falsity. But when that same information is shared with non-members, then the qualified privilege no longer exists and the information can be defamatory. Church leaders must be careful concerning how any information regarding alleged sexual misconduct is communicated with the congregation. Several options exist. First, leaders may send a letter to church members apprising them of the allegations. It often is preferable for members to be apprised of such incidents by their church rather than through the news media. If you decide to send members a letter, note the following considerations. First, send the letter only to active church members. To ensure this occurs, you should check the church records. Second, be sure the letter and envelope both contain the words privileged and confidential. Third, limit your remarks to facts that can be substantiated or established. Fourth, have an attorney review the letter before it is sent. Another option is to inform the congregation during a membership meeting. If you choose this approach, it is imperative that you adopt procedures to ensure that no non-member is present in the audience when the information is communicated. To reduce your legal risks, the information must be communicated only to active members. As I just noted, be sure to limit your remarks to factual information and do not express opinions. You may wish to prepare in advance a written statement that is approved by an attorney that is read to the congregation. Often congregational members will desire more information. The board should designate one person to handle questions, and that person should fully understand the concept of qualified privilege and only disclose information when a common interest has been fully established. Any disclosure should be strictly confidential on a need-to-know basis. It is imperative for church leaders to do the right thing following an incident of abuse or molestation. Tragically, church leaders often respond inappropriately to such incidents, and this not only re-victimizes the victim, but also dramatically increases the risk of litigation. As I noted earlier, when confronted with an incident of sexual misconduct, church leaders often deny that it occurred, minimize its severity, or blame the alleged victim. Such responses are inappropriate. Church leaders should frequently contact the victim and the victim's family to express concern and make the services of the church available to them. Assure the victim that the church takes very seriously any allegation of sexual misconduct. Emphasize that the church does not tolerate incidents of sexual misconduct and considers such incidents to be unscriptural, subjecting the perpetrator to discipline. If the allegation is credible, make sure the victim understands that a report will be made to the proper authorities who will conduct a thorough investigation. Offer to assist the victim and the victim's family in finding a counselor. Be responsive to their concerns, keep them informed, and let them know that you care about their well-being, safety, and their concerns for justice. A case of child sexual abuse in a church often results in extensive media coverage. Designate a spokesperson for your church and refer all requests for information to that individual. This person should be knowledgeable about how to respond to the matter in a discreet, informed, and diplomatic way. In some cases, the media will interview several church leaders who have never given any consideration to responding to such inquiries. In such cases, conflicting and contradictory statements can abound, and the public will develop a negative impression of the church. This is avoided if only one person is designated to speak for the church. Your spokesperson should be able to communicate the church's concern for all victims of child sexual abuse, and that the church takes all allegations seriously. The spokesperson should also understand the legal concerns associated with making public comments, and be briefed by the church attorney before meeting with the media. As we conclude, let's review the key points in responding to an allegation of abuse. Be prepared in advance. Have a plan to respond to allegations of sexual misconduct if they should occur. Take all allegations seriously. Do not engage in denial, minimization, or blame. Follow up on all allegations. Collect in writing all relevant information concerning the allegation. Promptly fulfill any state reporting obligation concerning child abuse. Notify your insurance agent, appropriate judicatory leaders, and church attorney concerning the allegation. Place appropriate restrictions on alleged perpetrators of misconduct until the case is resolved. Maintain strict confidentiality concerning all information. Communicate with congregational members on the basis of their need to know under the restrictions of qualified privilege. Have a plan in place to respond to the media. Finally, provide support to the victim and the victim's family.
Yes, we're very grateful that we have not had to respond to any allegations. We do attribute that to the fact that we have a plan and a program in place that protects both our children and our teachers, and we're grateful for that.
Having a prevention plan makes a difference. Yet no church can completely eliminate the risk of child sexual abuse, and no church ever expects to have an allegation. But it happens, and it can happen in any church, including yours. Being prepared in advance is the best way to begin the healing process, to reduce the pain and suffering, and to protect both yourself and your church from potential legal liability.